Karen Agnifilo filed yesterday a letter to the judge in Luigi's case on the state prosecution asking for certain sanctions, recusals of prosecutors, and dismissal of the charges because she claims that the prosecutors obtained illegally Luigi's medical information, reviewed that information, and that Aetna provided that information in violation of HIPAA laws. I've gotten a ton of questions on this, some of which, ask me about my personal experience, having been a former prosecutor in New York City, whether this subpoena stuff is normal, if it happens frequently, what could possibly be the remedies. Our DA's office is allowed to review people's medical records, stuff like that. So I'm going to try to answer as many questions as I got. First off, let's just review what she says happened. She says that the DA fabricated a court date in a subpoena that they wrote. They said that I think a certain date in May was a court date and that therefore Aetna needed to provide certain materials to them by that court date. She's claiming that court date never existed, so they lied about that. And also she's upset that Aetna provided a lot of information that they shouldn't have. And the other big argument, of course, is that the DA didn't say that those materials were returnable to the court. Instead, they said that it should be returnable directly to the DA's office, which she says is a violation. And in fact, both sides agree that the DA's office did issue a subpoena ducis tecum, which is like an investigatory subpoena to Aetna. And they agree that the DA was subpoenaing certain material, that being Luigi's account number with Aetna and the dates of coverage. What ended up happening is Aetna received this subpoena and provided the DA's office not just with that information, but with his entire medical record, which is a total violation of HIPAA laws and should never have happened. What makes matters worse, Karen argues, is that the DA's office, instead of, seeing this 120 plus page packet that came from Aetna and discarding it right away, which they should have done, they should have known that that wasn't responsive to their subpoena because the response would have just been one piece of paper with his account number and the dates on it, not 120 pages. Plus, she said that that booklet of paperwork had things on the front that said confidential and made it very clear that the materials had to do with protected information. And instead of chucking it and informing the defense right away about it, they apparently reviewed at least part of it. They admit to that. And they did not inform the DA of their receipt of these materials for a week. Now, bottom line, do I think a judge is going to dismiss the murder charges because of this? No, I do not. Do I think the judge is going to force Joel and company to recuse themselves from the case? I don't. I actually want to say, I don't know what's going on with the paralegals at the Manhattan DA's office. No offense to them. But this is the second snafu that I think could be attributed, at least in part, to the paralegals. Previously, we saw that a paralegal was listening to a phone call that was a privileged attorney-client call between Luigi and KFA. That paralegal, I think, was dismissed from the case, if not her job or his job completely. And you should know that at DA's offices, paralegals are typically the ones to draft these subpoenas. I understand Joel signed off on it, but there's no way. I mean, not there's no way, but I'd be surprised if he's the one who drafted it. And the person who drafts it is usually the one who puts the date in there. By the way, that calling it a fake subpoena is a little histrionic. It's not a fake subpoena. DA's offices are allowed to subpoena materials. We're going to talk about how they're supposed to do it, but they are absolutely allowed to. The only thing that was not correct on it was the date. And again, everything is pretty much boilerplate on these subpoenas. All of the wording, for the most part, is the same for every single subpoena. Basically, it says, you're commanded to appear with certain materials that are necessary for the prosecution of this case. Now, let's backtrack for 1 second. We meaning society, doesn't want a DA's office to have total unchecked power to subpoena people and materials places. And so for the most part, these subpoenas have to be returnable to the court so that there's some sort of check and oversight with respect to these materials before they're disseminated to anybody. So the first mistake is that it was not returnable to the court. Now, a lot of times what DA's offices do, and I think probably what happened here, is that the subpoena itself, the legal document itself, says that it is returnable to the court. And I think it's possible that this subpoena did say that. Returnable to the court means that the materials that they requested should go to the court so that the court could review it before giving it to the DA's office. But what sometimes happens, the DA's office sometimes does to kind of circumvent or usurp this, is they will add like a friendly little letter on letterhead attached to the subpoena. So it's not like an official legal document, I guess, ish. And the letter will say like, if you don't want to show up to court with all of this stuff and you don't want to be burdened with it, you could just send it to us. Have I seen that before? Yeah, I have. It allows the DA to basically say, well, look, we did the right thing. The subpoena itself says it's returnable to the court so that we're not ordering anybody. That would be illegal. Ordering somebody to like come to a DA's office or bring materials to a DA's office like straight out is not okay, because when you say like it has to go to the court, you're basically acting as an officer of the court. And so there's protections, but you're not supposed to like just say things like this, like medical information to come to you. So that letter that probably said like, oh, if you want to avoid the hassle of going to court and bring it back to court and instead just give it straight to us, that's a no-no. That's not good. Now, Aetna, what's their liability? They're not going to be held liable in this case in particular because this is the Luigi prosecution. So nobody's going to hold them accountable. But do I think they committed a HIPAA violation and could potentially face a lawsuit here? Absolutely. Because it does seem, and I'm not giving the DA's office credit, by the way, but they didn't actually ask for his medical records. They just asked for small pieces of information about him. And instead, Aetna clearly misread, misinterpreted, whatever, idiotically provided protected information to the DA's office about a defendant. Like very bad, very bad. Like Aetna, I think, is going to be in a lot of trouble. By the way, nobody's asking, or at least no one asked me, like why I think the DA's office is subpoenaing his account number and dates of coverage. I'm just going to give a guess that like maybe they're looking to establish certain relationships that he had with different health insurance companies so that they could show the motive here. I'm not sure, but that's where I think it's going. And it's interesting because I don't know if a judge would have signed a subpoena for that information. Like maybe they don't really have good cause to request that very private information. Even if they weren't requesting his full medical records, the account number itself and the dates of coverage is also protected information. So I definitely think it needed to go through a judge. A judge needed to inspect that, what's called in camera, meaning by itself in the courthouse without anyone else seeing it before it got disseminated to the DA's office. I'm not sure what the judge is going to do. Obviously, those materials cannot be used. They claim that they destroyed the materials, whatever, but they cannot be used for sure. Will a judge allow the other stuff? Maybe now a judge says, you know what, this is very tainted. This whole process stinks. Now it's going to be suppressed. Even the materials that you may have otherwise been entitled to had you done this the right way, like the account number and the coverage information, I'm going to suppress it. But no, I don't think the judge is going to dismiss the case or force the prosecutors to recuse themselves. So bottom line, are DA's offices allowed to see people's medical records and medical information? Sure, if they do it the right way and a judge approves it. But here it looks like it was really bad. Even if they didn't, request these exact pieces of information, the fact that they got it, reviewed it, and didn't have it returnable to the court is bad. Very bad.